Good afternoon, everyone. At the outset, let me congratulate all my fellow professionals on the most recent achievement for all of us as proud Indians. That is the successful hosting of G20 summit under Indian presidency. It is indeed a huge achievement, both as Indians as well as governance professionals, for it is good governance that inevitably finds its mention, presence, and deliberation in all such deliberations. So with that thought, I welcome you all at this 10th webinar of Master Knowledge Series under the able guidance of Shri Dhananjay Shukla ji. He is Chairman, Corporate Laws and Governance Committee, and President Mr. Manish Gupta, ICSI President. The Master Knowledge Series is an attempt of the Institute of Company Secretaries of India towards keeping our professionals updated with the most recent amendments. Before moving forward, I have been entrusted with the task of reminding all the practicing professionals that the ICSI has invited applications for the 5th ICSI Best Secretarial Audit Report Award and the 3rd ICSI Best PCS Firm Award, the last date of which is 25th of September. While for us, the awards are a way of recognizing professionals who have excelled in their respective fields, it is the moment to showcase their achievements and share the same with their alma mater. So coming towards the topic of today's webinar, the topic for today is SEBI, Prohibition of Insider Trading Regulations 2015. The law has since its enforcement playing a key role in protecting the interest of shareholders and investors and hence stakeholders in general. The stringent legislations have acted as a perfect deterrent for the corporates and those entrusted as guardians of the interest of stakeholders to exercise diligence in their conduct and avoid any misfeasance. Over the years, the law has garnered such limelight, and yet there remains some scope for it to be decoded in depth. Company secretaries in their roles as compliance officers are required to be well versed with the law in true letter and spirit. So considering the complexities of the topic, it seems benefiting that a dedicated session is conducted on the topic in the presence of experts. So to guide our way, I would like to welcome our guest speaker today, C.S. Narayan Shankar, the Executive Vice President and Company Secretary of Mahindra & Mahindra Limited. Member of the Institute of Company Secretaries, he is currently on the ESG and Sustainability Board of ICSI, a former member of Secretarial Standard Boards of ICSI. He has been member of committee set by Ministry of Corporate Affairs to review managerial remuneration. He was the member of ESOP committee set up by SEBI, which revamped the entire ESOP guidelines into regulations in 2014, and has also been a member of the committee which revamped the SBEB regulations in 2022. Under his guidance, Mahindra & Mahindra was twice honored with the Golden Peacock Award for Best Corporate Governance. The company has also been a recipient of Best Governed Company Award twice from Institute of Company Secretaries of India. Sir, it is an honor to have you here with us today. I request all our members to raise as many questions as you can and actively participate and gain knowledge from this session. With these words, I request Sir to take over.
Thank you. Just let me know whether it's in the PPT mode. You are able to see it?
It is visible, sir.
1 minute. So, thank you and ICSI for giving me an opportunity to share my views on PIT. I would like to start immediately on the topic. Before starting, just a disclaimer, as you're aware, the views expressed is of my own and not of the organization. And a second disclaimer, during the course of today's presentation, we are going to look into multiple case laws impacting whether UPSI, connected person, anything pertaining to trading window, the linkages between LODR with closure of trading window and so forth. The cases which I am going to refer are all in public domain. It was never with an intent to be critical about anybody, but the intention is always to learn a lesson or two so that we all are able to. As my dad used to always tell me, you don't have to do all the mistakes in your life. You can also learn from others. So the limited intent is only to learn and never ever to be critical. With this, let's start. As you're aware, what is insider trading? In simple terms, insider trading means trading in securities of the company based on unpublished price sensitive information. It is illegal and an unethical act by a person who is privy to UPSI and is going to use it to enrich himself. Okay, and need for regulation for existing of a fair, vibrant, and efficient securities market, ensuring fair market conduct in the securities market, and to prohibit, prevent, and punish market conduct which leads to market abuse. In India, while we had prior to 2015, we had a regulation, but it was substantially revamped in 2015. Regulations were effective from May 2015, which repealed the erstwhile 1992 regulations. Amendments were also made basis recommendation of the Vishwanathan Committee, and they were all effective from 1st April 2019. Okay, and now definitely a mention about ICSI. As you are aware, ICSI has come on guidance note on insider trading. It has guidance on ensuring compliance with the IPIT. It has guidance on best governance practices, guidance to board and audit committee to ensure proper system, various checklists to ensure and monitor compliance. So my humble submission would be, if at all you have not gone through it, please, I would urge each and every member. It's a masterpiece from ICSI, and it gets you all, whether it is interpretative letters, informal guidance, orders of AOs, orders of SAT, Supreme Court, all subject wise, and it will be a very, very good ready reference for all compliance officers. Now, since we have talked about compliance officer, let's do the starting of a definition with compliance officer. Compliance officer under PIT.
Can we have your PPT in full screen mode, please?
It's not there in full screen?
No, sir.
1 minute.
Yeah. I think it is in the down where volume button is there, na?
1 minute, huh?
Yeah.
That's okay. Yeah. I thought I had already. It's not still come on full screen?
Still not, sir. Actually, in the side, na, there are.
No, I've already, because in my screen, I'm able to see it in
now
full screen.
It is there. Now it is there.
Oh, great. Excellent. Thank you. So, compliance officer, as you're aware, a senior officer designated so and reporting to the board of directors, and need to be financially literate, responsible for compliance. Okay. If you see, there were a lot of questions raised on compliance officer reporting to the board and etc. So here is an interpretative letter which SEBI had given to one of the questions, and the questions basically was that can a person who is not reporting to the board act as compliance officer and update the board on the transactions related to insider trading quarterly, and can a company appoint more than one person? SEBI in this interpreted letter has made a mention that company at its discretion appoint any senior officer as the compliance officer, and that position will necessarily report to the board of directors. Appointing any other person shall not be in compliance, and in case of appointing more than one person as compliance officer, they should be held jointly and severally responsible. So hence, as you're aware, even the term financially literate has been defined as a person who has the ability to read and understand basic financial statements, balance sheet, P&L, statement of cash flows, regardless of the internal reporting structure in the company. The position of the compliance officer vis-a-vis PIT regulations must report to the board of directors. Okay. So now, having gone through the definition of compliance officer, let us go to the heart of the PIT, which is who's an insider. As you're aware, an insider is a person who's a connected person or in possession of or having access to UPSI. Let's peel the onion and let's peel each and every word as part of the insider. So first, let us see who is a connected person. Okay, a connected person is anybody who is or has during 6 months prior to the act, whether having a contractual, fiduciary, or employment relationship, is a director, employee, officer, or can even have frequent communication with his officer. So he holds a position involving, could be professional, business, temporary, permanent, direct or indirect. So long as the position allows access to UPSI or is reasonably expected to have access to UPSI, that person will be a connected person. So if you read the committee report, it is mentioned that they are conscious of the fact that once a person is a connected person, he should ideally not be regarded forever as being a connected person. Hence, if you see the heading itself, which talks about who has during a period of 6 months prior to the act. After much deliberation, it was felt that any person who has been a connected person during a 6 months period prior to an act of trading should still be regarded as a connected person. So what does it mean? It actually means this is broadly a bright line for attracting the deeming and notional implications in the eyes of the regulations. Indeed, if it can be shown that despite the passage of 6 months, there has been contact and there would lead to a reasonable prospect of UPSI having been accessed, and the consequence of trading would, and the definition and the clutches of connected person would automatically follow. Hence, if you see the language, any person who is or has during 6 months prior, hence even if a person is a designated person, if he resigns and he involves involving a position that allows access to UPSI, then in which case even post resignation, retirement, cessation of employment, he will still be a connected person for a period of 6 months. Very important for all compliance to know. So hence, after resignation, he will be a connected person for a period of 6 months. As you're aware, the charging section of Regulation 44, in case of a connected person, the onus of establishing that they were not in possession of UPSI shall be on such connected person, and in other cases, the onus will be on SEBI. So what is the first stage? The onus of showing that a certain person was in possession of or had access to UPSI at the time of trading would be on the person leveling the charge, and the person, the AO at SEBI leveling the charge, correct? Once SEBI fulfills this onus, then the person who has traded when in possession of or having access to UPSI is given a fair chance by SEBI to demonstrate that he was not in such position, or that he or she has not traded, or he could not access UPSI, or that his trading when in possession of such UPSI was squarely covered by the exceptional or exonerating circumstances given in Regulation 4.1.1 to 4. That basically, for Regulation 4.1 provision says that an insider can prove his innocence by demonstrating circumstances including matters mentioned therein. Okay. The key point, if you see in the last point over here, the last point is broken up into two parts. That is a position involving, if you are holding a position that allows access to UPSI is one portion of connected person, but the second portion is equally important. It is reasonably expected to have access to UPSI. So what does the term reasonably expected to have access to UPSI? In a particular case, Supreme Court has very nicely dwelt into it, and that interpretation really would help every compliance officer to say, what does the term reasonably expected to have access to UPSI mean? In this particular case, as you're aware, before even going to the case, the question was the non-executive directors do not have active participation in day-to-day affairs. They have minimal access to UPSI, and the source of UPSI would generally be only agenda or proceedings of the board meeting. So the key question here in this particular case, where Supreme Court was juggling was, can a non-executive director or say an independent director who have access to UPSI, can they ever have other than through agenda and information placed before the board or committee meeting? Any person is included within the ambit of connected person, which includes, as you're aware, we saw the definition is in front. It includes director, officer, provided the position allows such person directly or indirectly access to UPSI or is reasonably expected to have access to UPSI. Non-executive directors are persons who are not involved in the day-to-day affairs and are not in charge and not responsible for the conduct of day-to-day business of the company. A non-executive director cannot be presumed to be privy to UPSI unless it is proved that it was shared with the director or is part of the proceedings of the board. Correct? So hence, in this particular case, while Supreme Court was going through the provisions of connected person and the term reasonably expected to have access to UPSI, Supreme Court has very nicely interpreted that the term reasonably expected cannot be a mere ipse dixit. That means there must be sufficient material or material to support reasonable access to UPSI, correct? So that was the case in this particular case. And what it means is presumption of access to UPSI, through which he can have access to UPSI, even they will be a connected person. Hence, friends or acquaintances, even on social media, whether it's WhatsApp, Facebook, other social media, SEBI has used that as and mentioned that they are connected person. And if such persons trade while any information is UPSI, the onus will be on the person to prove otherwise, because the onus will shift on them to prove that actually they didn't have access or they are not a connected person. The second, when we are talking about investigation into insider trading, whether it is communication of UPSI, procurement of UPSI, in fact, the act of trading, as you're aware, the regulator has limited what I can say, communication of UPSI is very difficult nut to crack, correct? So hence, in all probabilities, they use the doctrine of preponderance of probabilities, because when you are doing civil crimes or not criminal, you're going civil, it is preponderance of probabilities allowed and you don't have to prove beyond all reasonable doubt, correct? And Supreme Court has upheld the high standards of preponderance of probabilities in Ajmera, Rakhi trading case. Charge of insider trading, Supreme Court has held in many of the cases, is one of the most serious charge in relation to securities, and having regard to the gravity of this wrong, higher must be the preponderance of probability in establishing the same. They mentioned that these principles can be applied to civil cases where the charge is to be established not beyond reasonable doubt, but on the preponderance of probabilities. And the courts generally use various yardsticks when they have to sustain an insider trading conviction based on preponderance of probabilities and where circumstantial evidence is used. So various factors are considered, such as access to information, relationship between the tipper and tippee, timing of contract between the tipper and tippee, timing of the trades, trading pattern, which trading pattern today is used across the globe, whether it is at India or even at SEC at US or UK or in the European Union. And the last one is attempt to conceal either the trade or the relationship between the tipper and tippee. So all these are very, very important, where they use the doctrine of preponderant probability in terms of tracking an insider case. But this slightly got changed with the last Supreme Court order in the case of PCJ. So let me just get, in PCJ, there were two material UPSI, which we will say, UPSI. The first one was they were considering a buyback. So UPSI 1 was in the period where they were considering buyback and prior to intimation to the stock exchange. Immediately post that, there was refusal for NOC by SBI, which was the lead banker. So UPSI too was the time where SBI has refused to give NOC for the buyback, and the time where the company intimated it, stating that they are going to withdraw the buyback. So there were two UPSI, one intimation for buyback and intimation for withdrawal. While the UPSI was still to go to the public at large, that there were certain factions of the family which traded on the stock. And the regulator said that while you was, as you're aware, when you was trading while in possession of UPSI, it is directly violative of PIT regulation. But here the Supreme Court said material evidence will be required to show that the person reasonably has access. Insider trading can't be presumed only basis proximity between parties. If it is not a connected person or an immediate relative, the onus to prove is on SEBI. That's what broadly the case stands for. Hence, one of the points which keep coming out of this is communication of UPSI ought to be proved by producing cogent materials like emails, letters, witnesses. Allegation cannot be basis alleged proximity in a manner. If parties are neither connected persons nor immediate relatives, as we said, onus is on the regulator to prove such communication. And in this particular case, as you are aware, certain faction with the family members who are not covered directly under the definition of immediate relative traded in the securities of this particular company, and they all probably shared a common residential address due to joint family of extended relatives, and the chairman's wife and authorized her husband and her husband's cousin to trade on her behalf, and SEBI held that all of them were reasonably expected to have access to UPSI, and hence they were deemed to be connected person. In the case of non-connected person, as I said, the proof is on the regulator to do it, and hence in this particular, in the absence of cogent materials, circumstantial evidence such as trading pattern, timing of trade, family relationship, Supreme Court said is not sufficient to prove that UPSI in respect was disclosed in violation of SEBI PIT. Most importantly, SEBI said that its earlier decision, both in case of Kishore Ajmejram as well as Dushyant Dalal, were cases pertaining to fraudulent or manipulative trade practices coming under SEBI FUTP and relates to interest and penalties rather than the subject matter of insider trading at hand. So what is it broadly saying today? That this particular case seems to now probably apply different standards when it comes to preponderance of probability and circumstantial evidence for insider trading cases with those compared to securities fraud cases. So in insider trading case, probably the level of circumstantial evidence and additional evidence would be much required today to be higher compared to securities fraud cases, where they say probably the Ajmera case would still hold good. Because Supreme Court has still confirmed that its judgment in Chintlapatti Srinivas Raju, which required that reasonable expectation to be in the know of things, can only be reasonable inference drawn from foundational facts. And hence foundational facts have to be completely correct. So Supreme Court had two major questions in this case. First, whether it was right in rejecting the claim of the insiders that the recipients of information, that is tippies, which we call, were estranged from the communicators, that is tippers, because there was an estrangement agreement. Second, related to whether the tippies can indeed be treated as insiders on the basis of circumstantial evidence. On the first of estrangement, Supreme Court found that there was an estrangement among the members, both professional and personal ground. There was breakdown in relationship between parties, and it is suggestive of the fact that communication of information about the company's affair was unlikely. But the more heart of preponderance of probability was the question number 2, which is whether we can rely on circumstantial evidence to indicate that TIPPs were in possession of UPSI. Because the earlier decision of Supreme Court in Ajmera sought to lessen the extensive burden of SEBI in insider trading case, which is acknowledgement in a manner of the absence usually of direct evidence in insider trading. However, the present case of Balram Kark in Supreme Court limits the applicability of Kishore Ajmera and effectively, you can say, enhances in a manner burden of proof from SEBI. Can we say that Supreme Court does not has completely eliminated the possibility of the use of a preponderance of probability? Answer is definitely not. It has not completely eliminated the possibility of the use of preponderance of probability or circumstantial evidence, which we call. SEBI's what I can say, reliance merely on trading pattern and timing of trading probably would be insufficient basis unless there is a new order of Supreme Court prove insufficient to discharge burden of proof. So hence probably some additional direct or circumstantial evidence is necessary to establish communication from the tipper to tippee. And mind you, it is quite a difficult task because this is something which getting direct evidence between the tipper and tippee is a very, very difficult task. But currently, given the current case, this is the particular case. Okay, so now we go to deemed connected person. Deemed connected, there are multiple people, whether it is holding subsidiary company, intermediate, immediate relatives, and so on and so forth. With regard to holding in subsidiary company, here is a company which was a listed company, and the subsidiary of this company was in a profit making, but probably suffered a major loss of more than 500 crores. The subsidiary and the CMD, group company and the CMD traded in the scrip of the company after the info pertaining to the negative came into existence, but before it was published. SEBI cracked and went against the company as well as the concerned KMP, and action was taken, even when the person said that there were not very many conversion with accounting concepts like impairment of investments, etc. SEBI said nothing doing. It is, if once you have access to such an UPSI, you should not have traded. So one immediate fallout is when you have multiple subsidiaries, till the ultimate holding company releases the results, you will never know which subsidiary has a loss, which will have impairment of investments at the holding level. Till that time, you should give a dictate across the group not to trade in the stock at all. The second element of deemed connected person is immediate relative. Immediate relative, as you're aware, spouse by default, irrespective of financial dependency and taking investment decision. However, the other relationships, whether it is parent, sibling, in-laws, which are mentioned in front of the screen, if they are dependent financially on such person or consult such person for taking decision relating to trading in securities, then they will come within the clutch of connected person, an immediate relative, and hence connected to the designated person, an insider. Okay. We now talk about determination of materiality for UPSI. Okay. And here is a particular case where a particular company, and this case will be equally important for determining materiality under Regulation 30 subclause 4 of LODR, as well as for PIT. Hence, it's very important. Here is a case of a company who had got 3 major orders for execution. Okay, the company was declared as the lowest bidder of the contract, and considering the magnitude of the orders, the information relating to these orders was price sensitive and was likely to materially impact, and hence coming under the clutches of UPSI. If you see, the 3 orders were crossing almost 80% of the turnover of the last year. Okay. However, what was the stand taken by the company? The stand taken by the company was, at the time of bagging the contract, it is not possible for the company to disclose the orders, 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 the the revenue to be owned, because if I am in an EPC type of a business, and if I have to execute the contract over a multi-year, that means say over a 4 to 5 years, the year-wise impact on the revenue of future years will have to be considered, and not the revenue immediately of the last year. SEBI, on the other hand, mentioned that a company earning a contract, if you have been declared a lowest bidder, and once you get a contract for an amount which is substantial portion of your turnover for the current year, it is coming within the clutches of UPSI, and you should have closed the trading window, thou should not have traded. So very, very important, because even when we are talking about bagging orders, or if you're doing any other, if you're getting an order, or if you're getting any contract which is materially important, materially crossing your thresholds, even the thresholds under Regulation 34, which is 2% of your turnover, net worth, 5% of your PAT. In all these cases, you will have to ensure that you disclose, and if it is price sensitive, you have to also ensure that you close the window, make necessary entries in the SDD. Now we come to material financial relationship, very important, and you will see the key difference in any, if you have any besides immediate relative, if you have any relationship where you have a material financial relationship with somebody, that has to be disclosed to the company. As you're aware, prior to the amendment didn't actually talk about that the 25% has to be on behalf of the designated person. The amendment which took place has now said that the material financial relationship shall mean a relationship in which one person is the recipient of any kind of payment, such as by way of loan, gift from a designated person during the immediate preceding 12 months, equivalent to at least 25% of the annual income of such designated person. So they have linked the 25% to the income of designated person, but shall exclude relationship when the payment is based on arm's length transaction. Okay, so there was an informal guidance given to a particular company where the crux, if you really ask me what was the crux was non-monetary transaction would also be construed to establish material financial relationship, and a DP is requested to disclose the names of the person with whom he has such material financial relationship. Okay, besides material financial relationship, as you're aware, you have to give names and PANs of immediate relatives, persons with whom you have the designated person shares material financial relationship, which is the current case, and also phone, mobile, cell numbers which are used by them. More importantly, you also have to give name of educational institution from which you graduated and names of your past employees. Because as you're aware, in a particular case, there were two IT companies where they were bidding for a particular contract. While one of the IT company got that award, the other IT company, the gentleman who was also equally bidding, were colleagues in the prior organization. They had a colleague relationship because he was working in the former company. The moment the bagging of the order was done, the person from this company who bagged the order intimated to the person who didn't bag the order, and the person who bagged the order traded on the stock. This is UPSI priority trading. This is close to the exchange. And hence, when the necessity that amount of orders has come down, you will have to give that they have a list of immediate relatives. You have material and financial relationships with the company. The designated person has given all the bases that are there, including the last employment relationship, correct? So the questions which were raised in this interpretive letter, the first one, whether non-monetary transaction will create a material financial relationship. So our answer to that was material financial shall mean a relationship in which one person is the recipient of any payment, such as loan, gift, that even non-monetary transaction would be construed to establish a material financial relationship. Very important thing, specifically as compliance officers to educate the designated person. Second question was, if if a DP has a material financial relationship with his immediate relative, then it is required to be disclosed separately in the category of a person with whom the DP has a material financial relationship. So again, the answer was, as an immediate relative, he may rebuke connectedness with DP. A DP is required to disclose the name of immediate relative with whom he has a material financial relationship separately in the category of person. Hence, disclosure of name of immediate relative and disclosure of person with DP with whom the DP has material financial relationship are two separate disclosures. Question number 3. A DP pays his granddaughter fees by depositing to the university directly. Such amount exceeds 25% of the DP's annual income. The details of which person should be disclosed was the question. Here again, as you're aware, the DP will have to disclose the name of the granddaughter, and in case the granddaughter is a minor, the name of both the parents and guardian, in addition to the minor granddaughter. Correct? Now comes to particular specific case which was given. A DP gifts a land to her daughter, the cost of which is more than 25% of DP's annual income. Also, such transactions were made even prior to this person becoming a DP, and a DP has credited his daughter's account with 2 lakhs as a gift, which exceeds 25% of the DP's income. The DP shall disclose the name of his daughter when disclosing the name of the person with whom he has a material financial relationship. So that comes out clearly, and hence this is all the more important to educate the designated people of this provision. The next question was, a DP deposited an amount to the account of his niece for payment of fees. Such amount exceeds 25% of DP's annual income. Here again, the DP will have to disclose the name of the niece when disclosing name of person with whom he has a material financial relationship. The last question in this case is not connected, which I told you the difference is post-amendment, the 25% is linked with the income, annual income of the DP. So in this question, the question is, a DP's maternal uncle sponsors a foreign trip of a designated person, which constitutes to be more than 25% of the uncle's annual income. So here, if you see post-amendment, the DP is not required to disclose the name of his maternal uncle, when disclosing the name of person with whom he has a material financial relationship. Why? There has been no payment from the DP side. However, if the DP would have sponsored his uncle for a foreign trip, and the amount would have been equivalent to at least 25% of the annual income of the designated person, then the designated person would have been required to disclose it. The designated person is required to disclose the names of person with whom he or she has a material financial relationship only when the designated person is a payer. So that was the key difference between the pre-amendment and post-amendment. Of course, it can be argued both ways in terms of a quid pro quo and others, but we are right now interpreting the law as it is, and that's the answer. Now comes the heart of the problem. When we saw compliance officer, we saw connected person, we saw access to UPSI, we also saw the interpretation of the term reasonably can have access to UPSI, correct? We also saw multiple connotations of including social media and how people, friends and acquaintances can come onto the clutches of connected person. And last, we saw prior employment relationships and material financial relationships disclosure. Now we come to the heart of the PIT regulation, which is UPSI. Prior to coming to the definition of UPSI, friends, the definition of UPSI has gone through tremendous changes. As you're aware, in the 1992 regulations, price-sensitive information was defined as any information which relates directly or indirectly to a company and which, if published, is likely to materially affect the price of securities of the company. Hence, prior to 2002, there was a definition of price sensitive information. And as you're aware, in the this is an old case law of HLL acquiring about few lakh shares of Brook Bond from Unit Trust of India on the basis of UPSI regarding the impending merger of HLL and BBL. Okay, when this matter came to SAT, one of the point was the proposed merger was generally known and was cited in various press reports which were revealed, which in a manner revealed the knowledge of the proposed merger, correct? So the loophole in the law was any information, even which was known in the media, could not constitute UPSI. That means if it's a leakage, which today we are struggling with respect to market rumor, which effect from 1st October 2023, which is going to come in place. If there is a market rumor, the earlier, prior to the 2015, prior to 2002, it could have been said that it is generally known and hence it is not UPSI. Everybody is aware, and hence you cannot prosecute me for being trading during when I'm privy to UPSI. So the amendment, as a fallout of this case, SEBI then amended the regulation in 2002, where they said, as part of unpublished, when they mentioned that unpublished means information which is not published by the company or its agent and is not specific in nature. And there they added an explanation which said speculative reports in the print or electronic media would not be considered published information. Hence, if there are speculative reports in, if it is a market rumor, for example, CAT itself doesn't change color from UPSI to price sensitive information, correct? Unless the company has specifically put it today in the website or you have specifically communicated to the stock exchanges. So hence today, after a lot of to and fro, right from the earlier regulations to 2002 and now to 2015, the current definition is any information relating to the company or its securities, again directly or indirectly, that is not generally available, which upon becoming generally available is likely to materially affect the price of the securities. And so this is the definition, and it has an inclusive definition. While this is the broad definition, it also goes on to say UPSI shall ordinarily include but not restrict to information related to financial results, dividend, change in capital, M&A, change in KMP, and of course material events in accordance with listing regulations was deleted with effect from April 1, 2019. So here again, if you read the committee report, you will observe that the listed illustration which you find, correct, are ordinarily in the nature of information that could affect the price upon becoming public and are not exhaustive. Merely because a particular type of event is listed in say 1 to 5 here, which is in the screen, it should not lead to inexorably being regarded as UPSI regardless of its potential price impact. Even for market rumor or for UPSI, price impact materially impacting the price is a major event or a major condition. For example, where a large company makes a non-material or an inconsequential acquisition of a tiny business, it will still come under the clutches of 4. But if it is not price sensitive, it may not come under the clutches of UPSI. Or, of course, some companies have gone to the extent of saying that if the rate of dividend that is declared for several years are the same, and it is as per a publicly stated dividend policy, should it? That would be taking it probably slightly beyond. But any tiny acquisition, incorporation of a wholly owned subsidiary, you will have to see whether the substance of the transaction is akin to UPSI. That means In a particular case, the judicial process, when it went into, the courts have taken a call that if the substance of the transaction is akin to a process performance improvement, the mere fact that it has been executed as an acquisition cannot in itself render the transaction material or price sensitive. Hence, if you see the first line in this slide, ordinarily, what is the what I can say, emphasis on the word ordinarily. And hence courts have said this is exactly the reason why the definition is prefixed by the term ordinarily, so as to allow parties to adduce factual evidence to disprove and rebut the price sensitivity of certain corporate actions, which is very important. Okay. And as you're aware, point number 6, the removal of all material events was removed with effect from 2019. Okay. As you're aware, as part of UPSI, today I was just going through, in fact, going through the SAT order, which came just on the first week of September, if I'm not mistaken, on 4th September. So there also SAT has said it is coming in terms of certain companies. This is a particular company who gives monthly updates, and whether monthly updates which you give in terms of your volumes, etc., whether those are UPSI. So there was a case which has gone against this particular company, but the AO had already ruled that it is UPSI and that the concerned person who is privy should not have traded. SAT order now, which came in the first week of September, confirmed the stand taken by SEBI just a week before, what I want to say. And SEBI that the corporate announcement regarding update on the real estate operation of a particular company was UPSI. This increase, that means there was increase in the sales volume in that particular company. They mentioned that was a price sensitive information and the appellant was privy to this information. Thus, the appellant was not only a connected person, but was also an insider in terms of PIT regulation. The corporate announcement regarding update on the real estate operation of the company is a price sensitive information. You know,
So that
UPSI.
means, the point number 6, which is deleted, that is also equally important. And I just wanted to ask why this is deleted, sir.
I'll tell you the logic. I'm coming to it. In fact, you preempted the next slide, but you don't read too much. We'll have to read in terms of price sensitivity and not mere deletion. The deletion had a background, which I will come to it. And today, if you see a new consultation paper that SEBI has taken out, where they have gone through the press releases of thousands of companies and said that how hardly minuscule percentage is treated as UPSI, and communication of many of the press releases are not coming. So today there is a move from SEBI to say that they want to reinstate this particular, which was removed in April 2019. But to continue in this particular case, the corporate announcement regarding update on the real estate operation was a price sensitive information defined, and SAT has now confirmed that if you're giving monthly updates, there is increase in sales volume, it will be considered UPSI. Some corporate professionals are trying to mention that this real estate operational update was part of the financial results, hence it is UPSI, but that you don't get anything from the definition. They have merely mentioned that if you're giving monthly update, it is UPSI, and all the rigors, whether in terms of having a self-test that you will not trade while in possession of UPSI, trading window closure, entry in SDD will automatically come in place. So if the appellant was in possession of price sensitive information, and if he has traded during the period in question, then even SAT is making a mention that merely taking pre-clearance, making requisite disclosure is not enough to show that the trades were not motivated by UPSI, because Regulation 4 prohibits any insider from trading in securities while in possession of UPSI. Of course, the provision to Regulation 4 of PIT regulation gives a window to insider to prove his innocence, but demonstrating circumstances, we said, under which he has traded. In the instant case, SAT said the appellant is an insider, and it was upon him to prove that the trades were not motivated by UPSI. And this entire concept of trade being motivated is probably coming again, I will touch upon it later, from another Supreme Court case, where suddenly today motive is coming. But however, across the globe, if you see, motive has got no connection. So long as you have UPSI, you cannot trade, correct? Of course, in this particular case, it was mentioned it is UPSI and the person was prosecuted. Now coming to the key question, which you have also raised, is my next slide. Does every disclosure to stock exchanges under Regulation 30 qualify for UPSI? And that is specifically because point number 6 today has been deleted, correct? Where we say that events in accordance with listing regulation. So what was the logic was removal of material events in accordance with listing regulation. That, see, if you see the basic logic, all material events which are required to be disclosed as per LODR may not necessarily be UPSI under PIT regulation. That means all material events which are required to be disclosed need not be equal to. Why? You have to understand two things. Material events specified in Regulation 30, read with Schedule 3. Today, Schedule 3 is gone manifold, correct? Are material in nature and are required to be disclosed to stock exchange. This disclosure is necessary to ensure that investors have access to relevant and accurate information so that they can make informed decisions. The classification of an activity as a material event or price-sensitive event serves different purposes. Disclosure of material event ensures transparency, whereas disclosure of price-sensitive information establishes a level playing field. Both are, there can be overlap, I'm not saying, but you have to understand the key subtle difference. So the key question is whether there can be a difference between what is considered material enough by the company to disclose to its shareholders and information that could be UPSI, which they will consider under PIT. Because the moment you consider it an UPSI, under PIT, automatically trading window closure, communication, SDD will all automatically flow. We all will agree that there would be commonalities, which I said. That means there are multiple cases in LODR, Schedule 3, which will have connotations or color of UPSI. But that is only because UPSI events are a subset of material events under Regulation 30. But the same is not the case vice versa. I hope I'm making my point clear. So in a particular order, it was stated that orders above 100 crores for an infrastructure company can be material event, but such orders being in normal course of business even cannot be termed as private price sensitive information, because today the company is saying even if it is material, I've disclosed it, but I'm not going to treat it UPSI. Similarly, in the case of an investment company where acquisitions are on daily basis, or a manufacturing company who gets orders for products or service, could constitute material event, but it will also have to go through the acid test of price sensitivity to ensure that is it UPSI 2. Materiality need not automatically lead to the assumption of the information being price sensitive. It will depend on facts and circumstances of each case. There are instances where intimation of material events to stock exchange would not lead to the assumption of information being price sensitive. Specifically, as you're aware, Regulation 30 today provides for different categories of material event, correct? And many of the categories today, if you are able to even see para A, issuance of notice, for example, to call letters, resolutions and circulars, change in directors, proceedings of AGM, analyst meet, they all are coming under Schedule 3, it will come under Regulation 30 broadly and under LODR. But this may not be probably a case for trading window closure. Change in auditors, if it has governance in some other cases, which is going to blow up, that it will have to be tested on a case-to-case basis when before application of specifically guidance, materiality guidelines, correct? While this kind of information, which you say holds relevance from the eye of an investor while making investment decision, it need not trigger a substantial price movement that would warrant it being classified as UPSI. So if you summarize, what are we trying to summarize? What is an event of closure of trading window? It is at the time of initiation of the project. And disclosure is conclusion of the deal. Trading window ends when disclosure is made plus 48 hours. And disclosure is sunlight, which we call, results in end of a closure. When you close the window, there is no sunlight. The moment it is disclosed, it is sunlight and the trading window closes. Hence, we say all trading window closure invariably would lead to a SC disclosure, but all Regulation 30 disclosure need not be UPSI under PIT. If not UPSI, it neither warrants trading window closure, nor does it warrant any entry in SDD. So hence, you can have different yardstick for trigger of trading window closure, different yardstick for trigger for disclosure to stock exchange, because both need not be what I can say coterminous. I am certainly not getting into an element of saying that there is no overlapping. We will see multiple cases in LODR, which I am going to touch upon later on, where there will be commonalities, whether in terms of acquisition and multi, which are price sensitive, and it could be material, where both will go. But as I gave you certain examples in the earlier slide, which is this, there are many examples even under the what I'm saying expanded Regulation 30 read with Schedule 3, which need not call for closure of a trading window. Okay, so let's go now to the key point. When we have seen what is UPSI, how does UPSI get germinated and the start and end date? As you're aware, the very first thing is for financial statements. As you're aware, for financial statement, besides financial statements, whether it is payment of dividend, change in capital structure, change in KMP, mergers, demergers, acquisitions, delisting, disposals. Today we are talking of sale of undertaking, which has come under Schedule 3, disposals and expansion of business, major business deals, estimated substantial bad debts, planning for bonus, rights, buyback, corporate action. You will have a whole list of items. And the key said, at what stage are you going to treat it UPSI? And at what stage are you going to enter it in SDD? Because companies will have different practice even for financial results. For some companies, preparation of financial results starts before the close of the financial quarter, while for other, the process may commence after the close of quarter. But as you're aware, today, there is no leeway given. Earlier, the word was can, today the word is shall. Hence, at least from the first day of the quarter, you have to close the trading window. Hence, as soon as UPSI relating to financial results get generated, it should be entered in the SDD. Trading in restriction period shall be made applicable from the end of every quarter, as you're aware, till 48 hours after the declaration of financial results. For example, access to ERP system, which is in the nature of UPSI, needs to be recorded in the SDD. A one-time recording of such details in the SDD per recipient would be sufficient. Hence, while if you're telling finalizing of financial results, say the last year, the quarter ended March 23, one entry can be made for persons in the accounts department at the start of the finalization process. Additionally, if the UPSI is shared with auditors, then details of audit firm, senior partner, other entities of the audit firm with whom UPSI is shared needs to be recorded. The audit firm, in turn, must also maintain SDD in accordance with the provisions of PIT. So when we talk about when is PIT germinated, when the information starts taking shape. Now we are moving from financial results to other events like M&A activities and other. So where the probability of going ahead with the information or the concerned event is higher than not going ahead, and such information is likely to materially affect the price of the securities, then this information will come under the clutches of UPSI and you will have to disclose it. In fact, just before the start, I just put this slide for the benefit of all. Just before the start of this program, I got a question that in view of the increased load on company secretaries, compliance officer for disclosing multiple items under Regulation 30 within 24 hours, how do we close window as assessment? I presume assessment means assessment of whether it is disclosable. For example, the question raised today is on tax litigation, correct? Where the tax litigation comes and you hardly have 24 hours within which you have to disclose. So if you see tax litigation comes under clause 8 of para B, which is where materiality thresholds can be included, and para 8 basically talks of pendency of any litigation or dispute, the outcome of which will going to have an impact on the listed entity. While this is a one-liner, the SEBI circular of July expands it substantially of saying that you have to notify the exchange even if your director, KMP, senior management, promoter, subsidiary become a party to any litigation. But the key thing in the circular is orders for and against the listed entity, there is a reasonability test which you can say. That means only those which can reasonably expected to have an impact are required to be disclosed. And hence, first, when you get a tax litigation, as you're aware, you will see if it crosses, you apply the materiality test. That means, does it cross the materiality threshold as specified under 34(1)(c) of the listing regulation? Correct? After applying the materiality test, the SEBI circular gives you a second ray of hope, that is applying a reasonability test. And what is the reasonability test? Outcome of the litigation or dispute should impact or reasonably be expected to have an impact on the company. And mind you, the term reasonably expected to have indicates that there must be a genuine expectation that the outcome could result in financial impact, correct? And how do you do that reasonability test? We generally say use the PPR test, which we call probable, possible, and remote test, which we call. What is probable? Means there is likelihood of that event occurring. What is remote? A situation where the chance of occurrence is slight or virtually negligible. And reasonably possible is when the chance of the future event or events occurring is more than remote but less than likely. For example, if you have to break the PPR into percentage, probable will be 70 to 75%. I am very sure of this occurring. Remote is less than even 10%. That means it's remote that this will happen. Reasonably possible, you can probably play between 10 and 70%. Okay. So one of the things when we talk about tax litigation is also, is there a provision going to be made? Because you will have to dip into Ind AS 37, which deals with provision, contingent liability and contingent asset. And if the dispute filed by the company or against the company, it could be a tax litigation, indirect tax litigation, where if the management, based on the PPR test and based on their assessment, does not feel that they do not have does not have a reasonable certainty of a possible outcome. If you say that I don't know whether this litigation will end up in a positive outcome, and there is an absence of a reasonable certainty, and that reasonable certainty will be based on my past experience. If I have myself gone into such cases similar in the past and I have lost, that means I am not sure, and hence it becomes a matter where probably I'll have to make a provision. And if I'm using a yardstick for making a provision, probably the same yardstick you can use for disclosure to the stock exchange. And sometimes when you don't have cases within your own company, you also say judgments passed in similar matters outside the company, but the ratio of which exactly can be applied to your case. And the third, which we say, there is definitely during provisioning discussion with auditors, and probably with their research, you may also dip into their research, whether that opinion is also matching with yours, and which you have to disclose. And where you see a reasonable certainty of a positive outcome, again based on past experience, judgment, and you feel it is not going to impact, although it is crossing the materiality threshold, there is no need for you to even disclose. And if you have come to a conclusion there is no impact on the company, the question of that being material, non-disclosure is there. So hence the question of closure of window in those cases does not arise, correct? The key question is, once you have decided that suppose a particular litigation would not result in financial impact to the company, and as such not disclosed, I have not even closed the window because I have taken a call. It's a documented process I have. In which case you have to be mindful, because every time there is a provision created, when you re-look at the case because of a development within that hemisphere or the development going to the next level, say from an AO to CIT, CIT to ITAT, ITAT to High Court, Supreme Court. And we will have a process of re-looking at contingent liabilities every quarter. That means I may shift some matters from contingent to provision. When you're doing that, that means I'm saying I am reasonably certain of some impact. Disclose it, and if it is material to your company and it is coming under the price sensitivity, close the window, even if it is for a small period. Of course, irrespective of that, people who are aware in the accounts and finance team are definitely will be bound by the self-test, that if they know that this provision is going to materially impact the price, they will neither be able to communicate, they should not communicate nor trade while this is there. So I thought, while I understand the problems being faced by the CS fraternity, because it is hardly 24 hours and many of the regulations, many of the disclosures, company secretaries are able to file it mushkil se within that 24-hour deadline. And in that, to also ensure that you have to close the window, have an SDD entered is a challenge. But as I said, if you do a documented approach, including the PPR test, it will really help you do it and set a process for both disclosure, closure of trading window, and other matters. So now, this was particularly point where we talked about linkages of LODR with UPSI, correct? Now we will go to the sixth element as to, we talked about financial results, we talked about litigations, closure of trading window, we talked about disclosure. We will now talk, when does UPSI get germinated in M&A transaction? Okay, we are going to talk about 4 case laws in this particular matter, and so that you get a feel that in M&A transaction, when is UPSI germinated, when is a window to be closed, and last but not least, entry in SDD. So here is a case 1. Here is a case of one pharma company acquiring the other. This pharma company approached the promoters. They had exchange of mail, and it was going for almost more than a year or so, correct? An important aspect of this particular order was that the moment the majority shareholder has agreed, it will get into the clutches of UPSI. UPSI will be deemed to have started or germinated. So in this case, the company which was looking out for acquiring the other company made presentations to the board. It met the advisors, it met financial advisors, and after all the presentation, the promoter of the target company, which we call father of the bride, agreed to the acquirer's proposal to acquire the target company and said that, can we get now into timelines? So that email of emails when they were scanning, that email of that particular company, they said that today the promoter has agreed for the acquirer's proposal, and this date, beautifully in that order, it is said UI, that is unpublished information, becomes UPSI, that means to unpublished price sensitive information. And from the time UPSI is germinated till the time it is disclosed, nobody should have traded. There was trades done in this particular by certain key people, and while they were trying to say that it didn't come to them, but they were part of the project team, and SEBI took action, and of course it was settled by way of an out-of-court settlement. We will now go to case number 2. Here is a case of a license and supply agreement between two pharma companies. In fact, in this particular case, SEBI imposed a very high penalty of 23 crores on the company and the promoters. Okay. This particular company said that normal supply license agreement is normal course of business. It is not material. And hence, because it is not material, I have not closed the trading window. And hence, there was delay even in disclosure because it felt, forget about the UPSI, it was not even material even for disclosure, correct? And during the same time where this was yet to be made in public domain, there was creeping acquisition made by promoters while in possession of this information. The key point coming out in this, and I've seen multiple cases, at least half a dozen cases I've seen. If a company decides not to close trading window, claiming it is not material, because it is my ordinary course of business, nothing, in which case the media communication also has to be in sync with this. So while in this case they say drug license and supply agreement is normal, it is not going to impact, and hence I have not closed the window. However, when the press releases were made, they said that it's an expansion of generic medicines in US and Europe. The press release said that it will dramatically change the company's product portfolio. And the press release went to say that while the current turnover from this product is 10 billion, it has the capacity of increasing it to 500 billion. So definitely, press release was talking a different language, and it was clear that it was material, and hence share price of the particular rose by more than 13%. And this was on the day when, in fact, Sensex and Nifty had closed down. Okay, so alignment of media report, corporate announcements, press releases, and what is the call you are taken for closure as well as disclosure, all have to be aligned. Because very important, everything has a connotation, everything will have a consequence. Here is the third case. The third case is again a license and supply. Sorry, this I've covered. Now we talk about trading window when UPSI germinates and use data analytics by SEBI. Okay, here is a case where there is a collaboration between two companies on certain products, and the key thing is, when will this collaboration, in this collaboration, when you are doing collaboration which will have a series of steps, when will UPSI deem to have been germinated in this case? So in this case, SEBI has beautifully used the 3-bucket case, which they say. That means they say UPSI will shift from one bucket to another, and they have 3 buckets, they have defined it. Bucket 1, they said timelines when parties have open discussion. Bucket 2, UPSI period. And bucket 3, final signing. Okay. The distinction between, timelines when parties have open discussions, UPSI period, and final signing is very important, because in the first stage of the deal, where timelines when parties have just opened discussion, which is bucket 1, discussions are exploratory in nature. Information generated at this stage is imprecise, okay, without a reasonable probability of the transaction going through, and more important, without any specific details. Okay. Now we'll come from bucket 1 to 2. When will a particular, for example, this transaction of agreement between two company on some product lines, correct? When will it be deemed to be in the UPSI bucket? SEBI says if there is high degree of crystallization, it proceeds towards greater degree of crystallization. There is reasonable probability of transaction going through. It inches towards higher degree of correctness, and it is done in a structured way by resolving issues. During the UPSI period, in this particular case, SEBI says with each passing day, unresolved issues are being ironed out. Outcome of the transaction moves towards higher and higher degree of concreteness. Discussions are centered around this resolution of specific issues. But the key point here it said is, it cannot be said with 100% certainty what will be the outcome. There will still be room for parties to change, modify decision till the time decision has been publicly announced, correct? However, they said merely because in this particular case, there were about 40 items that were yet to be finalized. Merely there are about 30-40 items. It can't be said that nothing is happening. And this is not an indication that the company can say that I am in the first bucket, which is timelines when we have opened, not the UPSI bucket. Because SEBI says negotiations represent a series of steps you take by respective teams working on the deal and senior management on either side. Because you resolve outstanding issues and fine-tune them, correct? Every day. For example, they went through the emails, and many of the emails have the heading of some thoughts to resolve stalemate, correct? But the more important thing in this particular case, while all this was going, at a particular date, the communication team of both the company got involved, and draft of press release and Q&A were exchanged between parties. Here is where SEBI took a stand that while we understand that it is bucket 2, you are telling it is still in bucket 1. We certainly know certainty of information can only be crystallized in terms of probability, degree of crystallization, and concreteness. However, on this day, when you have involved your PR teams, you have exchanged Q&A, I think there is an in-principle agreement you have reached. And according to us, UPSI has germinated on this day. They went through multiple emails which said we would like to have a call today to resolve as much, so that we've got limited issues to deal when we have a face-to-face. So SEBI observed the tone and tenor of mail. SEBI observed involvement of PR teams in this. And hence they said at this juncture, at least I'm going to say, there is reasonably, you have come to a conclusion, there is no possibility of failure of a deal, correct here? And you have involved your PR, you have gone into Q&A, you are almost going beyond the second to the third. So factors of UPSI will always have multiple buckets, timelines when you open UPSI and final signing. Industry will try their best to say companies that it is in the first bucket. There are multiple things which is to be ironed out. SEBI, based on facts and circumstances, will try to put you in by bucket number 2, because final signing is never a good. Final signing, you disclose, you don't close. So hence you have to understand, to determine UPSI, you have to go through a series of conundrums, going through nature of the transaction, progress of the transaction, outcome of various stages of negotiation, and increasing probability of transaction going through. So very important, I thought, because this gives you a different view at what stage, specifically when you are doing M&A deals, what stage is UPSI germinated? When do I have to close the window? When do I have to enter it in the SDD? This is the last case which we are going to talk on P&A, M&A activities. Here is a company in online education, which is now going to acquire a preschool, okay? It is in a manner a diversification strategy of this company. For the first time, I think they were to foray into a new line of business. SEBI says it's deemed to be expansion of business because it is one of the event which you saw the definition of UPSI. It is expansion of business is one of them. And for the first time, 1 crore was slapped as a penalty for non-closure of trading window. And mind you, this particular case, the fine was slapped on the company and not the compliance officer. But the day is not going to be fair for if compliance officer, we do not take our things seriously, we do not get into the details of the deal, then it is not far that even compliance officer themselves are going to be probably getting personal penalties also. And in this case, directors traded while in possession of UPSI. And this case is also an important case because one, they said that we are already there in the line of business, and this particular acquisition of a preschool does not breach their materiality policy. As you're aware, SEBI had given complete leeway to companies to come out with a materiality policy, and according to this company, disclosure and closure will happen only if the impact of any transaction is to crosses the 10% of turnover or net worth. Okay. So hence, if you see as a fallout of this and many cases, SEBI today, what is they telling? We are given discretion to you. Today, however, if the discretion is not going to be utilized properly, SEBI today has now come and said, I am going to now dictate what is going to be material, correct? So while content of the company was always that collaboration with this preschool was both are in the field of education, and therefore it is regular business, a normal course of business. We are remaining in the same domain area of operation, and hence we are not agreeing to the fact that it is diversification at all. And we are having a partnership with a small preschool which has only 10 schools, correct? And hence it is normal course of business, not material information warranting disclosure. Forget about closure of trading window. SEBI's contention was that it envisaged, actually this company envisaged acquiring a greenfield project to foray into preschool, but later on tied up with a partnership with this particular company. And they said partnership with a preschool and online getting into preschool is venturing into or expanding the business which was already into providing vocational business. This will squarely come under point number 4, which is mergers, demergers, expansion of business, which is one of the inclusive definition of UPSI, correct? And of course, this particular order was very, very critical about the process. They said there is a non-serious and casual approach on the part of the company towards compliance of PIT. If company had effectively closed trading window, designated persons would not have traded, and hence a high penalty of 1 crore was given. But the most important thing, which again comes out here, while not closure of trading window and disclosure, company took a stand that it is normal course of business. We are in the same line of business. That means education. And this company, this particular preschool only has 10 schools in and around Mumbai. But when they gave a press release, the press release said that the company is foraying into a new venture by opening almost 1,000 preschools in collaboration with this particular preschool. So again, time and again, I'm mentioning, if you're taking a stand for closure of trading window, you're saying it is normal course of business. It is going to be not material for disclosure. It is not having any price sensitivity. But if this is the press release you're going to issue, that 10 schools vis-a-vis disclosure and closure, but when it comes to price sensitivity and press release, we talk about 1,000 preschools. So it was almost 100x. Hence, be extremely careful as to how every element of your organization is well structured. The left hand and right hand is talking to each other, and nothing falls between these two. And now coming to the main topic now, as part of this, which is close to compliance officer, is that of structured digital database. As you're aware, we saw now UPSI, we talked about financial results, litigation. We also talked about germination of UPSI in M&A deals. We now come to the main, as a major responsibility of compliance officer is to ensure that whenever UPSI is germinated, we enter it in the structured digital database. Correct? Let me give you some background. As you're aware, once any UPSI share, this is we've just picked up from the Vishwanathan Committee report on fair market conduct. In this committee, they're saying that the company loses control over further issue of UPSI by those who come into its position. If such information is misused for insider trading, it will become difficult to establish a connection between the company and the recipient of information. Hence, it is necessary to have physical and digital trail of information flows of legitimately shared information, which will aid in investigation. Hence, whenever you are intimating UPSI, you will have to ensure that you also have to have, it is necessary to inform the recipient who is receiving UPSI that what has been given is confidential, and what you call is most important, doing an NDA or at least serving a non-disclosure notice. So when you're doing a deal under Regulation 3.3, which you're telling generally M&A activities come under 3.3, when you're opening your due diligence room, there you have to have a specific confidentiality agreement. It's a prerequisite. For non-3.3 matters, we say that you can serve a confidentiality non-disclosure notice, which will what will it broadly say is 5 or 6 things. Information shared is in the nature of UPSI. So the person knows he is receiving UPSI. Maintain confidentiality of such UPSI. Not to disclose such UPSI except in compliance with insider trading regulation. Not to trade in securities while in possession of UPSI. Mention to the recipient that the recipient will have to obtain company's prior consent in case UPSI provided to such recipient is used by such recipient for a purpose other than the legitimate purpose for which the company has provided. Also make a mention of duties and liabilities attached to the receipt of inside information. And last, mention liability that attaches to the misuse or unwarranted use of such information. In one of the points in the non-disclosure and confidentiality, I said, if the recipient is going to use it for a purpose other than the intended purpose. So as you're aware, one of the legitimate purpose is if you're doing it in a furtherance of your duties, then it is a legitimate purpose for you to get into the clutches of need to know, correct? For example, if I have multiple subsidiaries and I have to have a consolidated financial results which has to be given, correct? And as part of that, I get what is called fit for consolidation, FFC, from all. The accounts controller or the team consolidation team can use it only for the purpose of consolidation. That means if the accounts team is using it for a purpose other than the legitimate purpose, then it is not getting under the clutches of legitimate purpose at all. And hence those people will have to contact the compliance officer again and ask, here is it, whether I can, and be guided by the compliance officer, correct? So you will have to have list of all employees and other person with whom UPSI is shared. It will have to be maintained, confidentiality agreements in 3.3, notice will have to be served. I told you 6 or 7 points. And the agreement, if you're doing, also should deal with document management. That is, how are you going to deal with documents? Password protected, separate message for password, link to a portal, security, meeting protocols, security trading restriction, other confidentiality issues, and so on and so forth. And the next, we also talked about 3.3. And one of the things about 3.3 is today, when the board of directors of the company is of the informed opinion that sharing of UPSI for due diligence is in the best interest of the company. If you see, prior to the amendment, the word was that the proposed transaction is in the best interest of the company. The majority of the company is represented to the company that at an initial stage, it is going to be difficult for the board to say that the entire transaction is in the best interest. Only when it achieves some materiality, we'll be able to know. Hence, SEBI has changed this the language to say that what the board of director will have to only form an opinion that sharing of UPSI is in the best interest and no need of taking a call on the entire transaction. So here is a major difference between prior and this. The concept of SDD, as you're aware, was first introduced 1st April 29. It was based on the Fair Market Committee, and later on amendments to the provision relating to SDD were introduced. And the principal sections are 3.5 and 3.6, correct? So 3.5 broadly will say that board of directors or heads of the organization of every person required to handle UPSI shall ensure that the SDD is maintained containing name of person who have shared, name of person with whom UPSI is shared, number or any other identifier, that is you put the PAN account or any other number available. Such database cannot be outsourced, will have to be maintained internally, maintained with adequate internal controls such as time stamping and audit trails to ensure non-tampering of the database. What is the preservation period? Here it is. Board of directors, you will ensure that this SDD is preserved for a period of not less than 8 years after completion of the relevant transaction. And in the event of any investigation or enforcement proceeding, till the completion of such proceedings, okay, who all are required to maintain listed entity, fiduciaries, and rather every person who is required to handle UPSI. Capturing who are required to, what do you capture in SDD? From, to, and details. From means name of the person who shares along with PAN. To means name of the person with whom it is shared along with PAN. Details, nature of UPSI, time and date of sharing. Of course, I will skip the specimen of specimen, this SDD, etc., because it's now quite an acceptable thing. Of course, when we come to certain checks and balance, please ensure that SDD is maintained internally, that is on the company server, no third-party access is there, ensure non-tampering of database, declaration can be taken on a quarterly basis from all HODs of the company involved in the project for SDD maintenance. You will have to do a recording in the SDD irrespective of whether UPSI shared internally or externally. Many of the people ask a question that UPSI is just shared internally, and why there is a requirement of maintaining SDD. As you are aware, Regulation 3 comes within its ambit, UPSI shared internally as well as externally. Next, we said confidentiality agreement, confidentiality notice needs to be served, and except matters pertaining to 3.3, confidentiality notice is equally okay to go. Now we come to the 25th January 2023 circular of exchanges, where they said that they had done investigation of lot of SDDs which the companies are maintaining, and they said that under the get code page of the exchange website, the stock exchange would display that the company is non-compliant with SDD along with details of the compliance officer from the next trading date till exchanges have satisfactorily verified that the company has completely complied. This was soon followed with, as you're aware, there were circulars issued both by BSE and NSE on 16th of March, as well as ICSI on 25th April. Okay, as you're aware, BSE and NSE on 16th March issued circular on additional affirmations which are to be provided by a practicing company secretary in annual secretarial compliance report. Because SEBI wide that Feb order, correct, Feb circular had issued the format of annual secretarial compliance report, which was effective 2019 onwards, to be filed on annual basis. Hence, BSE and NSE now provide few additional information which are required to be provided by PCS while submitting ASCR and revision in the format of ASCR. The above circulars clearly now make a mention about compliance with 3.5 and 3.6, which is nothing but SDD. This was additionally supplemented by ICSI on 25th April, where they said that additional information to be provided while submitting ASCR will be: 1, prohibition of insider trading compliance, and that the listed compliance entity is in compliance with 3.5 and 3.6, which is basically SDD related clauses. We will now move to a major one, which is probably plaguing all compliance officers today, which is materiality threshold, correct? As you're aware, today, when you're talking about acquiring control or a stake, one disclosure is when you cross the 5%, and post 5%, any plus or minus 2%, you have to disclose. Besides this, today, there is a third element which you have to ensure for disclosure, and which will have implication for trading window closure, and which is if the cost of acquisition or price at which shares are acquired exceeds the quantitative materiality threshold under 30 subclause 4(1)(c). And what is those materiality threshold? Here it is. It talks of omission of an event or information whose value or expected impact in terms of value exceed the lower of the following three threshold. That is 2% of the turnover, 2% of net worth, or 5% of the average profit after tax as per last three consolidated financial statements of the listed entity, correct? Hence, when you are doing any acquisition, you will have to be extremely careful that earlier the disclosure was only triggered when you crossed a 5% or there is a plus or minus 2%. Today, equally, you have to see, even if that acquisition does not cross plus or minus 2%, if it crosses the lower of the turnover, net worth, or profit criteria, you have to disclose, and depending on the impact, also close the trading window. For example, acquisition, you're aware today, acquisition, instead of agreeing to acquire, they have now used agreement to acquire. A major change in the LODR. Coupled with this, SEBI has given a circular in which they have clearly mentioned that in case the board is taking an in-principle approval or approval to explore, which is not final, correct? And not final approval is given by the board, the same need not be disclosed under Regulation 30. So hence, when you're doing an acquisition or a sale of stake in subsidiary or associate or an agreement to acquire, and if the board is giving an in-principle approval, there are material things yet to be crossed and ticked, then you need not disclose at that stage. You can disclose at a stage where the agreement to acquire along with the delegated authority signs off. That means if you have delegated to a committee, when the committee meets and you are ready for an agreement, that will be the trigger for disclosure. So when you are, but the most important point you have to say, if it is price sensitive, if it is coming under the clutches of UPSI, you're saying it is material going to impact. If the same thresholds of 30, we talked about this threshold, if the same thresholds you are going to use even for trading window closure, which many of the companies are doing, then you have also to ensure that at that time, if you have decided it's quantitatively going to breach, then you have also to close the trading window, ensure communication of trading window closure, confidentiality notice, entry in SDD, so on and so forth. Most important why I'm mentioning this, because when you're giving a final approval, the closure automatically opens at that time Today, when you're doing an in-principle approval, you have to ensure that you tell the management that the trading window closure is going to be more larger, because till the time you're ready, till the time the delegated authority signs off and there is an agreement signed off, till that time we disclose, the trading window will be closed. And when we talked about this threshold, that any of the following, you also have to apply threshold. Let me tell you what are going to be the changes which you will see. For example, if I am a parent company is investing in a wholly owned subsidiary, there was never a requirement for you to disclose in the earlier regime, because you are owning 100%. Even if there is a rights issue, the percentage shareholding is not changing. However, today, even if there is no change in percentage shareholding, if the cost of acquisition exceeds the lower of this threshold, which is there in the screen, in which case, even if you are investing in a wholly owned subsidiary, and if suppose your materiality threshold, the lower is generally PAT, suppose 100 crores, then in which case any acquisition of shares, even if you're near subsidiary or wholly owned subsidiary, even by way of a rights issue, will require disclosure. Whether it requires trading window closure will be depending on the facts of the case and whether it is price sensitive. Every company will have to do that and accordingly take a call. Similarly, as you're aware today, even if you are going to dilute your holding in a wholly owned subsidiary, there is a trigger. So one, when you incorporate a wholly owned subsidiary, disclosure is required. Undoubtedly, yes, you are acquiring control. Whether mere incorporation involves trading window closure, no, according to me. But yet it will depend on the facts and circumstances of each case. If there are other connotations to it, trading window closure may be warranted. Similarly, while you were disclosing for wholly owned, today, even if you are diluting your stake even 0.1% in such a way that the wholly owned subsidiary ceases to be a wholly owned subsidiary, you have to give a disclosure. For example, if you are getting a new investor and the new investor, what he is going to invest is crossing the materiality threshold, which is there given under 34(1)(c), in which case it is a matter for disclosure, because anyway, it is ceasing to be a wholly owned. And if it is breaching the threshold, even quantitative for your trading window guidelines, you have to also close the window when you're taking a decision, correct? But on the other hand, if you're going to get an ESOP scheme for some employees, and on account of that, say the wholly owned subsidiary is probably not going to remain a wholly owned subsidiary, because ESOPs are granted, ESOP grantees are going to exercise shares, and on account of which, again, it will have to be case-to-case basis. While it will trigger a disclosure, whether it will trigger a trading window closure is yet for every compliance officer to see and have a documented approach in respect. And when we are talking of wholly owned subsidiary and cessation, there is a wrong phenomenon in certain people to say that cessation of wholly owned subsidiaries required to be disclosed only when there is a transfer of undertaking to the wholly owned subsidiary. The answer is completely no. When you transfer an undertaking, which is covered under Regulation 37A of 37A of the listing regulation, there, if you have taken exemption of a wholly owned subsidiary, there is an exemption to wholly owned subsidiary. That means if they're going to do a sale, lease, or disposal of an undertaking outside the scheme of arrangement to a wholly owned subsidiary, you don't have to go through that additional threshold of majority of minority to say that besides the special resolution, you have also to ensure that the votes cast by the public shareholders are more than the votes cast again. That means other than the special resolution, you also require a simple majority of the public shareholders. And the third point is public shareholders who are party to the deal will not be able to vote. For the first time, public shareholders will not be, so long as they're party to the deal. But if you have taken an exemption stating it is a wholly owned subsidiary, correct? And I will not go majority of minority. I will still go under section 181A of Companies Act, but I will not go under 37A. Then all the more important for you to ensure that you track that whenever you are going to dilute the wholly owned subsidiary, or whenever you are going to or if that wholly owned subsidiary is going to transfer it to another company, that will be another trigger for approval. And because sometimes we will lose track, the best our advice to many of the compliance officers is do not take that exemption. If you are broadly saying that there is going to be an investor which you are going to get into the wholly owned, rather go for special resolution, which anyway is required under 180. Go for majority of minority of public. Ensure that public shareholders who are there do not participate in the discussion, blank out them. And if you have not taken exemption and you make it specifically in your explanatory statement that there is an intent that the wholly owned subsidiary, we are going to get an investor, details are provided or broad plans are provided, in which case you don't have to then track whether that entity is further going to be transferred or when it becomes dilution. But the key difference is under 37A, it is approval. That is under 37A, when you dilute in the wholly owned, you require approval of shareholders. And in regulation 30, it is disclosure. So there is a difference in the approach in 37A and 30 is what I wanted to make a mention. That means irrespective of whether you have transferred an undertaking, you have to disclose when you cease to be a wholly owned subsidiary. But if you have transferred an undertaking and cease that company to be a wholly owned, in which case shareholder approval plus disclosure. And depending on the facts, where I've given example, you have to marry the trading window closure with the particular disclosure being made. For example, which I said, if a company ceases to be a wholly owned subsidiary or a subsidiary or an associate or becoming of either a wholly owned subsidiary or associate, there is a trigger for disclosure. Where is the trigger? Execution of agreement, undertaking actual sale of shares, or when you're breaching those materiality threshold. I will not repeat it again, it is in front. While there will be a disclosure, we saw in each case, you have today to take a concise call whether that will tantamount to a closure of trading windows. For example, we said if you see multiple of the regulation 30 matter, dividends, buyback, corporate action, undoubtedly the trading window needs to be closed. But agreements under 5A, if it is not tantamounting to change in management and control, if it is merely creating a liability to say that, for example, if I am having a group of companies, I probably give an undertaking to say that I will not enter into a business where my subsidiary is doing. That may be, if it is in the normal course of business, no need of a disclosure, correct? However, whether if there is no management or control issue in that agreement, whether trading windows are required will be a case-to-case basis. So a normal template will be that agreements having impact and control, impact on management and control of the company, where the company is a party to such agreement, trading window will be closed, because if you are not a party, you will not even know, correct? And other cases, trading window will be on a case-to-case. Same is the case with fraud, defaults of KMPs, including the new requirement of change in directors, resignation of auditors, we said, resignation of KMPs, one-time settlement. For example, if there is a resignation plan, of course, trading window will be closed in all cases. But matters like appointment or discontinuation of a share transfer agent, if it is routine, I may disclose it, but I will not require a closure of trading window for one. For example, if there is a one-time settlement with a bank, trading window will be closed in all cases. If there is a winding up petition, again, you will have to see whether that particular case filed against is material for you to close the window. Proceedings of AGM, we said, not required to close the window. It is a trigger for disclosure. Amendments to memorandum and articles, again, case to case. Schedule of analyst meet, again, not required. If you say announcement of through social media is a new requirement under a clause, schedule 3. Trading window closure not required, because when you are disclosing it in a social media, it's already in public domain, correct? Similarly, 19 and 20, which is what I can say, the major pain areas for company secretaries today, because where there is action initiated under 19 for search, reopening, investigation, you require to ensure disclosure. And when it is matters pertaining to search or seizure or investigation, and you have disclosed prior to disclosure, if you are already aware, you have to ensure that you close the trading window, because if the criteria is breached and that particular action is without any materiality, correct? And the key difference between 19 and 20, 19 uses the word actions initiated. That means even action initiated, it need not be the final order. But in 20, which talks of fines, penalties, suspension, the words used are action taken or orders passed. Action taken means if there is a show cause notice, for example, for a penalty, need not be disclosure. Because there they have carefully used, as I said, you have to ensure that you interpret every word in the listing regulation. If the word use action taken, then if there is action initiated for a penalty, need not be disclosed. But if it is an action taken for a penalty, then it needs to be disclosed. Again, question was, if the penalty is disclosed, penalty is coming as part of the litigation, whether it can automatically go into the family of 8, which is part para B. Difficult nut to crack till SEBI comes out with some clarification in this. They have a standard board and an implementation committee. Many events are being considered by them, and we as compliance officers should hold to say what is really coming out in that particular standard, correct? And we talked of even market rumors, correct? Whether even for market rumors, can we have a restriction on the mainstream media? Can we have some guardrails to say that if I have genuinely denied a rumor, or I have made a confirmation that yes, there is something going on, and tomorrow if it doesn't happen, will the company be sued under FUTP of having a wrong UPSI being communicated to the market? Many of the areas which are still open, but it will have to be taken a call as and when the more clarity emerges. As you are aware, it is a new area, and every company secretary is also struggling in terms of closure of trading window as well as disclosure. Besides the materiality threshold, which we talked about, 2% of turnover, net worth, 5% of profit, you also have the last clause which puts onus on the board and qualitative criteria. And when we are talking about qualitative criteria, generally use two tests. We call it price impact test. And what is the second? We call it reasonable investor test. What is the price impact test? Any information which relates directly or indirectly to the company, and which, if published, is likely to materially affect the price. That's a price impact test. And there are documented approaches which many companies have. And the reasonable investor says that if the information is in question is likely to be used by a reasonable investor as part of the basis of his investment decision, and therefore likely to have a significant effect on the price of the securities, then it will cover both under closure of trading window as well as disclosure based on the reasonable investor test. And significant impact on price, but of course can never be quantified because it will always be in hindsight, correct? But percentage change or otherwise, because it will be due to various reasons. However, basically, some factors can be considered relevant to a reasonable investor's decision. For example, information which affects assets and liabilities, financial condition of the company, major developments in the business, information previously disclosed to the market, and there is a continuity of that event, and omission of which is going to create further issue, is all going to come within the clutches of disclosure and on a case-to-case basis, trading window closure. The next point is a very important point of to say, if you have a positive news, would you buy or sell a security? And if you have a positive news and if you sell, would you be liable for insider trading? That means the trades done by you are opposite to the UPSI which you have, correct? Here is a particular case where notice is sold and not purchased share while in possession of a UPSI. There was a major announcement of the company's collaboration with another company. So hence the question was, can insider be guilty of insider trading if an opposite transaction is done? Can any person selling shares prior to a positive news be charged for insider? Correct? Second point, insider has not gained any undue benefit of the UPSI. Third point, shares were probably in this particular case sold for making purchase of self-occupancy, property, etc. And last pre-clearance was taken by the company. Okay. Objective of PIT is prohibiting UPSI, abuse of UPSI, hence diametrically opposite to common law. If it is a diametrically opposite transaction, insider has not taken advantage or undue benefit to the exclusion of others, correct? And what is insider trading trying to charge? Fiduciary duty of insiders not to take advantage of their official standing, access to superior information which is in the nature of UPSI, and to short charge what we call ordinary shareholders. If you see old SAT judgment, even in Chandrakala, of course it was under the old regime in SEBI, entity privy to positive UPSI, they said, is likely to purchase and never sell shares prior to publication of UPSI. Even the high-level committee of NK Sodhi, even they had made the mention that if the insider's trades are contrary to the nature of UPSI, such trading ought not be treated as a lawful lang, and this was broadly a principle to be followed. However, if you see the regulations 4.1, it clears all doubt because an explanation is now added to 4.1 with effect from April 1, 20. 4.1, as you are aware, is a charging section. No insider shall trade in securities that are listed or proposed to be listed on a stock exchange when in possession of UPSI. And what does that explanation today has come out? When a person who has traded in securities has been in possession of UPSI, his trades would be presumed to have been motivated by the knowledge and awareness of such information in his possession. Hence, as per UPSI, effect of UPSI on security can be negative or positive. Here, the noticee claim was, if in possession of UPSI, I would have sold and not purchased. It was found incorrect because what the regulator is trying to say, possession of UPSI does not presuppose upward movement of scrip. However, here again, in the case of Abhijit Rajan, okay, again, the key question which was raised over there, that the share was sold for some CDR purposes, okay, and there was some cancellation of shareholders agreement which resulted in the company gaining very hugely in terms of order book value. In such circumstances, the Supreme Court said an ordinary man of prudence would expect an increase in the value of the shares and would wait for the market trend to show itself if he actually desired to indulge in insider trading, correct? So for the first time, at the Supreme Court stage, you getting into facts of actual gain or loss is while it is material, but the motive is also equally material. Okay, this is probably not been the case, and hence this particular case of Abhijit Rajan is specific to facts of that case, and we will require much more clarity in more cases of Supreme Court to really gauge as to how the impact would really have on 4.1, correct? Because Regulation 4.1 is very clear that if you are in possession of UPSI, I am going to presume that every trade is motivated by that. There is a presumption the regulator is going to have. So this particular case law of Abhijit Rajan is slightly getting into the motive, and we will require some more case laws to more emerge so that the motive element, how do you get into that motive element or not, is yet to be seen in further cases of the Supreme Court. There were other slides, but I think I am mindful of the time. I think it is already 5, Deepa. It's already 5. So I think, with your permission, Deepa, I will like to pause now, and if there are any FAQs, we can go for it.
Yeah, lot of content, sir, in your PPT. Lots of content. Thanks to you.
So first of all, go ahead with the.
We have certain questions, but I think majority of you have already covered. Like there is a question as to how to maintain SDD. You have detailed this.
Correct.
UPSI Regulation 30. You have covered everything. 2-3 questions are there. If you permit
Yeah,
me,
go
sir,
ahead.
I can. So the question is, in case of ESOP financing, whether employees are required to take pre-clearance from compliance officer?
So ESOP is very clear that ESOP is completely exempt both from trading window closure, pre-clearance, as well as contra. That means
that is clearly
exempt, and it is clearly even mentioned in the FAQs. They can even go to the FAQs of SEBI. Next.
In income tax or GST department level, substantial tax demand is UPSI or material event under Regulation 30, even if it is not judicially established. So
litigation, as I mentioned earlier, I've covered this completely. I don't want to cover it entirely. I get a complete slide and of materiality, reasonableness, and if it is breaching that materiality threshold, it is a trigger for a disclosure, definitely.
So one last question, whether who is responsible to track the trade of connected persons like auditors, vendors, etc., whether company or connected person himself?
So the requirement under PIT is to track for designated persons when the trading window is closed, and never for connected persons. It is for designated persons.
Okay.
Of course, if there is an inquiry at that time, you will have to, definitely. So just let me first thank ICSI and thank all the people who have probably joined into this session. I don't know how many. And if all the people.
Around 8,300 something.
So thanks to all of them for patiently listening and being patient with me. And I have tried my best. It's quite a complex subject. It is impossible to cover everything. I tried my best not to get into mere theory of what you can say definitions and just again pasting the same sections. It would not really add value. We have tried our best out of our experience to say which are the cases probably which will impact compliance officer more, which are the cases at the Supreme Court, and how compliance is going to be a challenge. I've tried my best, but thanks to everybody, thanks to ICF for inviting me, and thanks to all those people who have joined. And I hope I've come up to your expectations somehow, somewhat in trying to peel the complex structure of PIT, correct? I always remember last time when I was doing a session, Amrita Nautiyal was introducing me, and she introduced this subject in a very, very funny manner. They're saying, she said, you better listen to Narayan Shankar on PIT, nahi to aap pit mein gir jaoge. Pit means kadda. So that will always remember. So thanks a ton again. Thank you. Over to you.
Sir has shared lots of definitions, the app definitions in detail, the multiple case laws, and on that basis, lots of advices are given to the compliance officers, to the company secretaries with regard to this PIT regulations. So really a great webinar, full of knowledge enhancing content. So I formally and sincerely thank you, sir, for sharing your knowledge and experience in such a detailed way, and giving your time to the institute and to the for the professional
My
fraternity.
pleasure.
So, and now I also formally thank to all the participants who have raised the queries, who have given their time and saw this webinar, attended this webinar. And on behalf of the Institute, I thank you, sir, once again. And
Thank you. Thank
this,
you.
we are closing this session. Thank you so much.
Thank you. Thank you.